Earlier this month, two conservative law professors announced they would publish an article to be published next year in the University of Pennsylvania Law Journal arguing that Donald Trump is unfit for president. Professors William Baude and Michael Stokes Paulsen argue that unless Congress grants Trump an amnesty, Trump will not be able to seek re-election or retain the presidency because of his behavior regarding the January 6 events. This claim is based on Baude and Paulsen's interpretation Article 3 of 14th Amendment. According to this interpretation, it was stated that holders office such as President, who had sworn to support Constitution, will engage in revolt or revolt against same thing, or giving aid or consolation to his enemies, will no longer be able to do such a task. A few. Laurence Tribe, a liberal law professor. J. Michael Luttig, a conservative former judge of U.S. Court of Appeals, wrote an article for The Atlantic in which they essentially supported view advanced by Baude Paulsen, the former president's efforts to disrupt 2020 presidential election. Its consequences. The resulting attack on U.S. Capitol places him directly under disqualification clause, is therefore unfit to serve as president again. Luttig was once on the Republican list of Supreme Court nominees. Has recently become an outspoken critic of Trump. Luttig and I recently spoke on the phone about whether Trump was actually disqualified. During our conversation, which was edited for length and clarity, we discussed mechanism by which Trump would be removed from state vote, different objections to Luttig's argument, and why he thinks Supreme Court might be involved. You write that Baude and Paulsen concluded that Chapter 3 requires no law, criminal conviction or other judicial action to carry out his order. So Chapter 3 is self-executing. I don't want to question the answer. But this means that no statute or judicial decision by Congress or any finding in court, for example, because of a conviction criminal case, is required for substance to operate against someone who has formally sworn to support the United States Constitution and who subsequently engages in an uprising or rebellion against the United States Constitution. This was one of biggest unanswered questions until Baude Paulsen's extensive research and scholarship on the substance, including congressional legislation, is necessary. Whether a particular person participated in an uprising or insurgency, a conviction for same is required. He ordered that this person be banned from serving in the United States in the future. What would be an example of something else self-enforcing in a constitutional amendment? Let's say a 32-year-old in a particular state applied to participate in the ballot, and it was undisputed that that person was 32 years old, not 35. The Constitution itself will authorize the state election officer to disqualify that candidate from the